Hey, good morning, everybody. Welcome to Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Happy Sunday. Thank you for joining us for Sunday Funday. Happy Father's Day. Happy 35,000 subscribers to Courtroom Confidential. Thank you guys all so much. That's a wonderful Father's Day gift to wake up to. Bez Nancy says, Happy Father's Day. Thanks for working on your special day. I appreciate that. I already received my cards in bed, handmade by the little ones, along with my yearly gift of socks that Tiffany gets me. And you say, socks isn't the greatest gift. It is the greatest gift because she gets me socks with the girls' faces on them. So I have socks now with one little face on them, and then we added two little faces, and now we have socks with three little faces on them, and it made me very happy. And then Tiffany said, by the way, the company will not allow you to do more than 3 pictures, so that means we're done. So I guess that's officially it. But good morning, everybody. Miss Kitty and Rainy Day and Best Nancy and Sarcasm. Thank you all so much for being here. I want to thank everybody for already this morning. Just a lot of really fun new members. Lindsay Brillhart and Gina Gilmore and Sandy Theed. I hope I'm saying that right. Sandy Theed and Maureen from Monterey. Here, I'll put these up. I should be putting these up. How do I do this here? There we go. Lindsay Brillhart and Gina Gilmore and Sandy Theed and Maureen from Monterey, thank you so much. And Laura Waldy gifted a membership. Appreciate that. Rachel Woodward is a new member. And to Shy Gal, Sonia for gifting a membership. You are all so very kind on this Father's Day. I appreciate it so much. But I appreciate most of all you guys being here on a Sunday. My name is Joshua Ritter. This is Courtroom Confidential. I am a former prosecutor. I was a prosecutor with the LA District Attorney's Office for 10 years. I left and went into private practice as a criminal defense attorney. This is Courtroom Confidential, where we do our level best to present to you objectively both sides of the courtroom, and we hope that we do that. And this is, of course, Sunday Funday, my favorite show, where we take your questions in voice messages and we answer them live. And we've got a lot of them today, a lot of really fun ones. So let's just jump right into it, right? I'm going to make sure I didn't miss any announcements that we wanted to talk about. I think I covered everyone. Thank you so much for being here, everybody. We're going to, take questions and start putting people on the map. Let's get into it. Starting out, who's kicking us off this morning? Can you hear that? No? All right. I think the volume might be low. Hold on. Let me start it again.
Oh, hello, Josh and crew and community. I was just wondering, how difficult is it to become a great interrogator? The police have to do it within the investigation room and the attorneys within the courtroom in public. What's the difference, the subtleties between those two things? Thank you. Sorry, Denise, Melbourne, Australia.
The volume was a little low on that, but I'm gonna just tell you guys what was said. This is Denise from Melbourne, Australia. So Denise, thank you so much for calling in and for kicking us off this morning. I did my best to try to enhance your audio, but that's all right. I was able to hear it. Calling all the way from across the world. Denise's question is about how does a person, and this, she says, applies to both police and lawyers, become a great interrogator? And I love this question because I think this is a very important skill for both police and lawyers. It might be slightly different between the two. Obviously, police have kind of different goals that they're trying to accomplish than the lawyers in court, but I think the one talent or the one skill that you can develop for both that makes them next level in this regard, as far as being an interrogator, being a cross-examiner, being someone who can ask good questions and elicit information out of someone, and that is the ability to listen. I think that above all else. We're going to talk a lot about Karen Reed this morning, and I know this question wasn't directly about Karen Reed. First of all, June, thank you so much. Zune Sidlakis, for gifting 20 memberships. That's incredibly generous of you. Thank you very much, June. Always appreciate you. We're going to talk a lot about Karen Reed. I know this question wasn't directly on Karen Reed, but I think that case has a good example of two very, very good attorneys, Alan Jackson and Hank Brennan. I know there are people in the chat who love either one of these gentlemen, despise either one of these gentlemen. I have, first of all, I know Alan, just in full disclosure. I've known him for 2 decades now. I've worked with him. We were partners at one point. I know him well. I don't know Hank Brennan at all, but I am trying to be as impartial and objective as possible and say that I think they're both incredibly talented. They're both very different. They both definitely have different skill sets, but I think where they both distinguish themselves in court is exactly to Denise's question about being good interrogators, good people on cross-examination and asking someone questions. Anyone can do direct examination. Anyone can say what happened next. Anyone can say, after you heard the gunfire, where did you go next? Then what happened? Then what happened? I mean, you're just leading somebody through something. Not that there's not more skill involved in it, but cross-examination is where good trial attorneys really shine. And these two have really shined on their cross-examination. And I think that you can say the one skill that they show above most is their ability to listen. They are not so caught up in their own minds and where they want to go and their own little script of how they expect this cross-examination to go. They are listening very carefully to the answers being given by the witness that they're asking questions of, and their ability to pivot off of those questions. Farm Girl, thank you so much for the membership. Appreciate that. They're quick on their feet. They listen, somebody gives an answer, and they immediately respond to that. Alan did that several times. Somebody would say something like, I don't know, something, I know there's plenty of good examples and none of them are coming to my mind right now, but somebody would say something like, well, I didn't think about it at the time. You didn't think about it. How could you possibly not think about it? The whole world is, falling apart around you. There's somebody dead in the snow. All of these things. And he would just take that one little response of theirs and turn it into something else entirely and make it a moment of magic. Same thing with Brennan. People would say things like, I remember one of the experts said something along the lines of, he asked him a question, do you that was it. Do you endorse reports that have your signature on them? And the response, I think it was Dr. Wolf, said generally. And he goes, generally? What are you talking about generally? We're talking about science and specifics here, sir. I don't want generalities. I want specifics. You couldn't do that, and you couldn't be effective if you weren't listening. And you can tell the attorneys who are not as good, maybe very good, but don't reach this next level of talent because they're the ones that aren't listening, and they let those little gems pass them by, and they don't have that quick on their feet ability to pivot off of that answer and see where it leads them. And sometimes that means going off script and going into uncharted territory and being brave enough to do that. So thank you, Denise, for kicking us off. Great question, but I think that is the talent to me that is most valuable for a good trial attorney. All right, let's keep it going here.
Hey, Josh and Susie crew. This is Sarcasm. I don't have a question this week. You're probably thankful. I just wanted to let you know that I have been extremely biased against defense attorneys pretty much my whole life, for reasons of my own. And I'm so happy that Gisela shared your channel and I found you. I love your insight, your point of view. I learn something every day when I watch you. I also have started following 2 other defense attorneys. But I really appreciate you. I think you're amazing. I don't always agree, but I appreciate you and your amazing mods and this community that you are building. Thank you for doing what you do because it helps us survivors and warriors kind of understand how you perform your jobs as defense attorneys. So again, thank you so much. I appreciate you, and I hope you have a really great Sunday.
Oh, sarcasm. That really touches me. That is very, very, very nice. Thank you so much. I know where you're from. You've told us before. You're calling from Fort Bragg, North Carolina. So we're going to go ahead and put that on the map. I listen. First of all, you said you found me through Gisela. I got to thank Gisela and Grizzly True Crime. They are huge supporters of us. She is so fantastic. She has been, behind the scenes, one of our biggest cheerleaders, and in front of the scenes, just kind of telling everyone about our channel. And I'm so grateful. I know for a fact we will not be here where we're at today if it wasn't for her and her help. So we're huge fans of Gisela and the Grizzly community. So thank you for that. You say you were biased against defense attorneys. I was biased against defense attorneys. If you want to find the most biased against defense attorneys group of people, go to prosecutors. I mean, when I was in the prosecutor's office, the idea of what private defense attorneys especially do was just kind of like, oh boy, that is the dark side. You don't ever want to go there. So it was a big kind of ethical and moral, emotional transition for me. Could I do this? Do I want to go to the dark side? And I quickly realized it is not what I think. The world is not so shaded in black and white. It's much more gray, and that there's a very important and serious job that defense attorneys do. So thank you so much. And I appreciate you saying you don't always agree with me. And I appreciate you still being here, even though you don't always agree with me. I don't think we could be talking about these things if we agreed on everything. It's just going to happen that there's going to be things we don't agree on. But one of the things I am most proud of this community is how respectful everyone is of those disagreements. And that's healthy stuff. Listen, that we're talking about trials, which is the most adversarial, combative kind of world you could be living in. And so, of course, there's going to be some disagreement, but sarcasm, I really appreciate those kind words. I'm going to be thinking about that all day. And thank you so much for calling in. From Fort Bragg, North Carolina, that was sarcasm. All right, let's keep it going here.
Hi, Josh and CC crew. Happy Sunday. This is Alex calling from Southampton, England. I apologise. I'm going to ask about Karen Reid. If Michael Proctor were to be called by the defence as a witness, would he be better off, do you think, pleading the Fifth Amendment? Would that look better to the jury, or do you think that would look worse? And if he does plead the Fifth, does that allow the defence to still question him? Anyway, just curious. Thanks. Have a great day. Bye.
Thank you so much, Alex. Bringing in the UK for the first time today. Alex calling from Southampton, England. Appreciate the question. I will say, because we skipped last Sunday and I received all the hate mail for doing that. No, but everybody was upset, as were we. And I'm glad that we're here again. But some of these calls are calls that we were unable to get to last week when the Karen trial was still going on. But I thought this question, though we know the answer now that Michael Proctor has not been called, I think it's still a great question to consider the strategy behind all of that. So Michael Proctor, and I don't think I acknowledged Maureen here. Hold on. Let me just thank Maureen really quickly. Maureen from Monterey. Happy Father's Day, Josh. Thank you for spending part of your day with us. Oh, it's my pleasure, and thank you guys for spending part of your day with me. And happy Father's Day to everybody, to the fathers and to the daughters with fathers and the fur fathers and everybody else. Thank you for being here. So this was a big question, and I got to tell you, I was surprised. I really thought that Brennan was going to call Michael Proctor. And I thought the reason he would do that is that it was so obvious the role that this person played in this investigation. He was the lead investigator. And I thought by not calling him, that might send the signal of they're hiding from this person more than they should. And I thought, okay, he'll call him and he'll try to steal the defense thunder and say, let's go through your text messages. Let's talk about all the awful, awful things that you did, sir, and try to steal some of the sting from what happened last time, where Alan Jackson just had an absolute field day with this guy. And it really was a pivotal point in the trial last time around. But they didn't decide to do that. And I think his strategy, he didn't decide to call a lot of people. He didn't call the Bryanses. He didn't call Proctor. There was a lot of people kind of missing, you could say. And I think his strategy overall was, listen, I'm putting on my case. This is what I need. These are the pieces I need to put together to prove my case. And if you, defense, want to put on your case, then you're going to do it during your case. And there is a strategic advantage to that as well. It is not a small deal, the difference between examining someone on direct versus cross. On direct, you cannot control them as much. You cannot lead them down a path. You cannot ask leading questions. So it's hard. When you're on cross, you get to kind of grab the leash and bring that person wherever you want. So I think he thought, you know what, you're going to do it. You're going to do it on direct, and then I get to cross this person. And by the way, cross-examination of a friendly witness to you is about the funnest thing to do in the world, because you're just having a field day, because then you know every toss-up is a slam dunk with that witness. Anyhow, they didn't. But part of your question was, what if he took the fifth? So, few things to consider here. One, first of all, he could not take the fifth in the middle of his testimony. In other words, you can't get up, start to testify, then when you start to get questioned about other things, take the fifth. What'll happen is that, first of all, it's a nightmare. It looks, the optics of it are absolutely hot garbage. And secondly, the judge can strike all of the testimony for failure to allow for effective examination of that witness, okay? Because you have a constitutional right to fully cross-examine someone, to fully examine someone as well. And if they're just refusing to do that midway through, there's an argument to be made that you want all of their testimony stricken. Then the next question becomes, could he be compelled to take the stand just to take the fifth in front of the jury? That is rarely, if ever, done, because there is this kind of theatrical moment to it that judges usually won't allow, because of the reasons that jurors will likely draw inferences from that might be inappropriate. The biggest example you can think of this is Mark Fuhrman. It's funny how Michael Proctor and Mark Fuhrman, I feel like, will forever now be kind of tied in our collective consciousness. Mark Fuhrman was the Proctor of his day, and he became the boogeyman of the OJ trial. And he testified, and he was going to be re-examined, and instead, in a hearing, he took the fifth in response to every question. Now, we all remember that. We all remember the scandal of that. We all remember the shock of that. But what you may not remember is that took place outside of the juror's presence. That was done in a hearing outside of the juror's presence to essentially see would he take the fifth. And the reason that Judge Ito did that, I wish we had put up a picture of Judge Ito because it's always good to see his face, is because he didn't want the jurors to draw inferences from that, because people hear the fifth and they immediately think that person's committed a crime, especially when you're asking questions like, I think they did ask of Mark Fuhrman, did you ever plant evidence in this case? And he again pled the fifth. When you plead the fifth, you have to blanket plead it. Again, you cannot pick and choose the things you're going to answer or not answer. So it was clever for the defense to ask questions of Mark Fuhrman, like, did you ever plant evidence? Because he's pleading the fifth, not in admitting that he did, but just in making a blanket plead of the fifth. And you can imagine if that was done in front of the jury, how they might have reacted to that whole thing. So, I know we've kind of gone around in circles on this whole thing. I think, though, to kind of round out our points here, I also wonder if Proctor could have pled the fifth. In order to plead the fifth, it can't just be, I don't want to answer questions. I'm not comfortable. What you're asking me will subject me to embarrassment. It's that you have to be under the threat and peril of actual criminal prosecution. I don't think Proctor's in any threat of criminal prosecution. He's been fired. He's been reprimanded. He's been, disciplined. But there's no, as far as I understand, no threat of criminal prosecution out there. So it could be that he could have been compelled to testify and asked and brought in a lawyer and said he intends to plead the fifth. And Judge Cannoni could have said, I'm not going to allow that. You don't have a Fifth Amendment right here. You have a Fifth Amendment right to not incriminate yourself. You don't have a Fifth Amendment right to just refuse to testify if you've been rightfully subpoenaed and you have knowledge that's important to this case. So in any case, prosecution didn't decide to call him. And surprisingly to me too, defense didn't decide to call him. And instead, I think they just felt like, listen, we've got all the bad stuff about him out there. And we don't want this wild card on the stand during direct examination. I mean, you can imagine the scenarios that could be presented where he could be asked a question on the direct that would open up the opportunity for him to, you don't have the same ability to ask these leading yes or no questions. You're asking open-ended questions, and he starts to, have a field day in response to that, and says a bunch of stuff in front of the jury. For the defense, I'm saying that you don't entirely want him saying. So, great question, Alex from Southampton. Thank you so much for joining us, and thank you so much for asking that question. Navin says, to bolster the Commonwealth could offer immunity to Proctor to remove the need for the fifth. They could have done that too. I don't think they even needed to, but it never even became an issue, which was surprising. So anyhow, let's keep it moving here.
Hi, Josh. This is Jana Frieslander calling from Nokesville, Virginia, outside of Washington, D.C. I was wondering whether or not you think that the appellate court is going to grant rehearing en banc in the Donna Adelson case. For many, many years, I worked for a federal appellate judge, and we seldom granted rehearing en banc. Just want to know what you think. Thank you so much for all that you, Tiffany, and the mods do. You guys are terrific. Also, it was wonderful seeing you on STS. You and Joel are my favorite guys.
Oh.
Talk to you soon. Thanks. Bye.
Oh, thank you so much, Jana from Nokesville, Virginia. We'll put you on the map. Again, this is Jana's asking a great question about the Donna Adelson case, but we've heard the news on this. The court in Florida has denied the en banc hearing on bail, rehearing on bail. Just to get a little bit into the weeds on this so that we understand what Jana's question was about. If you remember, the defense attorneys in the Donna Adelson case have challenged the judge. And the way it works in Florida is first you challenge the judge and send it straight to the judge himself. And that judge makes a determination on whether or not you have a legal basis, a prima facie case for challenging him. The judge denied that. They then appealed that to the Court of Appeals and said, hey, this judge missed the ball on this one. Court of Appeals says, no, he didn't. He did the right thing. The defense attorneys, not to be deterred, then asked for a rehearing en banc, spelled ENBANC. Because we're dealing with the law, we're always going to try to find the way to say things in other languages just to confuse the heck out of everyone. But what this basically means is that you want the rehearing heard in front of the entire appellate panel. Courts of appeals have several judges sitting, but only 3 judges, depending on the jurisdiction, will hear each case, and they all kind of rotate. So you just randomly get assigned 3 judges to hear your case. They make a decision. When you're asking for it to be reviewed, you're asking en banc, you're saying, I want it reviewed not just by those 3 judges, but by everybody, the entire panel of judges. And the reason for this was they felt that this was such an important case, such a disturbing abuse of judicial discretion, the fact that he had signed a warrant dealing with the matter in front of him, blah, 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 blah. We want the entire Court of Appeal to hear this. And they said, thanks, but no thanks. And my final thought on this is that this is not shocking, as Jana says, and that's an incredible background that you have. Thank you for sharing that with us. Jana says she's never seen it. It rarely ever happens. But the primary reason for it is judges rarely overrule judges on the same level as them. Judges who sit in courts of review, in other words, judges on the appellate court who are reviewing trial court stuff, they'll tell a trial court judge you screwed up. But if you're asking an appellate court judge to review what his neighbor did, the guy who has the office just down the hall from him, that's not going to happen. That rarely ever happens. You can kind of imagine why, but that was denied in the Donna Adelson case. Great question, Jana. Thank you for sharing your background with us. Lindsay Brillhart, thank you so much. Says, love watching Sunday Funday. Thanks for this, Josh. Love that you're here, Lindsay. It is my happy time of the week. So thank you for joining us. All right. Who do we got next here?
Hi, Josh. My name is Tiffany. I'm calling from a town called Horseheads, New York. I know that's a strange name. Very quick history lesson. A man named General John Sullivan was leading an expedition through the area during the Revolutionary War, and the horses weren't doing too well. Nobody was doing well, really. And they had to put a whole bunch of them down, and later those horses' skulls were found in the area, and so the settlers named the town Horseheads. But yeah, so anyway, my question is kind of silly, but I was just I've been curious about it for a long time. Back when I was like a tween, a movie came out with Ashley Judd called Double Jeopardy, and the premise, this is really ridiculous, but basically she was framed for killing her husband and finds out he's alive, and then decides when she gets out that she is going to kill him because she can't be convicted of it again. My question is there any scenario where that could even possibly happen? Like if she, after getting out of jail, took him on a boat again and pushed him off and really killed him 20 years later, could she not be convicted of it again? I know the answer is probably no, because it takes place at a completely different time, but just curious about it. So thank you for listening to my silly question. Bye.
Tiffany from Horseheads, New York. First of all, thank you for the history lesson on horseheads. That was fascinating. That will now be some brain worm I'm never going to forget about. And I will be sitting at a pub trivia day and have an answer for that when that ever comes up. So I appreciate that. And then you asked about Farm Girl. Thank you so much. Happy Father's Day. Love all you do. Thank you. Well, thank you, Farm Girl. Appreciate all your support and all that you do. Double Jeopardy from 1999. I love this question. Ashley Judd and Tommy Lee Jones. First of all, little trivia. Tommy Lee Jones gets top billing, even though he's in the film for about a third of the time that Ashley Judd is. So do what you want with all of that. I watched this forever ago, and then I got to tell you, we watched it again last night. Tiffany and I, not Tiffany from Horseheads, but Tiffany, my wife. And we enjoyed it. And it is a very enjoyable, entertaining movie. I said it is like if you took every 90s thriller and put it into an AI program, I think it would spit out Double Jeopardy. It's just like got every kind of 90s thriller cliche in it, but it's fantastic and it's fast moving. And April says she loves it. I loved it. We were sitting there and we're both like, this is great. It's got plot holes big enough you could drive a truck through it, but it's still fantastic. But it is premised on this kind of funny yet ridiculous idea. So, not to ruin the film, because you find this out early on, and I won't tell you the ending, but Ashley Judd is married to this man. I forget the name of the actor. He's an actor you've seen everywhere. Tiffany probably remembers the name, My Tiffany, or maybe maybe Horsehead's Tiffany. And they go on a boat. She falls asleep on the boat. First plot hole is nobody's got an anchor down, and it's the calmest waters on the ocean you've ever seen. But she wakes up in the middle of the ocean after sleeping. She's covered in blood all over the boat, bloody knife, and her husband's gone. And come to find out, her husband had called the Coast Guard and said that his wife stabbed him, and now he's disappeared. She gets tried for murder. Chihuahua Mama says, literally, these Sundays are my learn cool new things days. Yes. If you wanted to know more about the 1999 film Double Jeopardy, buckle up. So she gets arrested for murder, tried for murder, convicted for murder of her husband for something she cannot remember. Then she's got a little boy. She's in prison. She calls to speak to the little boy. And all of the little boys in another scene in the room, she's talking to him over the phone. And then you see the dad enter the room, her husband, and the little boy goes, "Daddy." And the look of shock that comes over her face, and she realizes that her husband had in fact faked her death. And I don't want to give you any more details because you should go out and watch it. But then the premise of the film and the title comes from a jailhouse lawyer tells her, by the way, you've already been convicted of murder. You can't be convicted of murder again. You could go shoot this guy in the middle of the street and there's nothing anybody could do about it. So adventure follows. And it's just Tommy Lee Jones as a parole officer, and it's him chasing her down. It's basically that Harrison Ford movie all over again with Ashley Judd as the lead role. It's fantastic. It's ridiculous, but it's fantastic. Alicia K. Mayo says, happy Father's Day, Joshua, and to all the dads out there, and the women also doing double duty as mom and dad and the fur fathers. Yes, very true. Thank you, Alicia K. Mayo. Anyhow, Bruce Greenwood played the husband. He's fantastic. He's one of those kind of, what do you call him? Character actors that he's great. And he's great in this movie too. Anyhow, the question though is, could this be true? Could she actually, having been tried and convicted and served her time for the murder of her husband, by the way, she only does about 6 years for the murder of her husband, go out and kill him because double jeopardy has attached and she can't be retried for murder? I have to tell you, Tiffany, I thought about this way too long. Like, I really tried to figure this out. So here's my ideas, just kind of shooting from the hip on this thing. First of all, we've all talked about dual sovereignty. So the feds could go after her if she were to go shoot her husband in broad daylight for murder again. I guess there's an argument there. Secondly, she could still be sued, though that's not really the point of the question, because civil does not, it's only criminal double jeopardy. But then we get to the point of she's already been punished for this crime. I mean, that's not a small point, right? She's been convicted for the murder of her husband and been punished for it. Now, is she committing another crime? Yeah, but she's already been punished for that crime. So it's not as silly as it is. It's not even that ridiculous of a premise. Here's what I think would actually happen, though. I think she would get arrested for this new murder. And I'm not saying that's what happens in the movie, so I'm not ruining anything. I think she would get arrested for this new murder. The prosecutors would make a motion to vacate her conviction for the prior murder that she did not commit. Now they know. She would be exonerated for that. She could probably try to sue the state for the time that she did on the murder she didn't commit, but likely wouldn't have much of a case, because then they would try her for the new murder of her husband. I think that is probably how the whole thing would play out, which, by the way, does not make for an exciting and sexy thriller, but I think that's probably how it would all work out. I don't think that they could just try her again for murder. I think they would actually have to do something about that prior murder, because there is a double jeopardy issue there. So I think they would vacate her conviction and then try her for murder again. Anyhow, it's free on Paramount Plus if you guys want to go check it out. We watched it. We enjoyed it. We were screaming at the TV, but we were having a good time. Thank you so much, Tiffany from Horseheads. Never forget that name now. All right, let's keep it going here. That's not me. That's a technical issue.
Josh, my name is Lori Feeney, and I am from Bolivar, Ohio, which I'm sure has never been on your map before, just a little south of Canton, Ohio. My question is about the defense arguing for a judgment of acquittal, which seems to happen during every case I observed. First of all, what was the original intent of the judgment of acquittal? And do you think that it's overused today? After all, isn't that why we have juries? To determine if the state has or has not met their burden of proof. It seems like arguing for an acquittal should be reserved for the most ridiculously weak cases, at least in my mind, but I'm not an attorney. Thank you for taking my question, and thanks for all you do.
Lori from Bolivar, Ohio. Let's put Bolivar on the map. You are correct. This is the first time we've heard from Bolivar, so thank you for representing. I love this question, Lori. Judgment of acquittal. Where did it come from? Is it overused? And how important is it? First of all, it is crucially, critically important. It is, by the way, a motion for acquittal or judgment of acquittal is brought up in every criminal case. So if you want to talk about it being overused, it's brought up in every case. The vast majority are denied because, to your point, it is usually reserved for the most ridiculously bad cases. But this is the entire concept. It goes back to the foundation of our whole criminal justice system, the concepts of presumption of innocence and burden of proof. A criminal defendant is presumed innocent. That is where you're starting from. You know, and this is kind of a hard concept for people sometimes to wrap their heads around. Many times I will, in voir dire of jurors, I will say, right now, ladies and gentlemen, you pick some random juror number 14. Right now, you've heard no evidence. Right now, you've just heard that my client has been accused of X, but zero evidence has been presented to you other than you know his name and you know what he's accused of. If right now you had to vote, how would you vote? And you'll get answers like, well, I couldn't because I don't have all the information, or, well, I'd be undecided, or whatever it is. And you try to not embarrass that person and go, wrong, 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 wrong. The answer is you'd have to vote not guilty, because that's where we're starting from, is not guilty. And it only is until the prosecution and possibly reaches the point of burden of proof beyond a reasonable doubt that you can even say the words guilty. So right now, he is not guilty. And it kind of drives home that point. And that is the point, too, of a judgment of acquittal. If we could show that, this comes from Federal Rule number 29, Kaylin. Yeah. This is the kind of model federal rule that every single jurisdiction has. But it's, it talks about before the submission to a jury, after the government closes its evidence, or after all the evidence, the court, or on the defendant's motion or the court's motion, must enter a judgment of acquittal if evidence is insufficient to sustain a conviction. So basically what you're saying is the defense doesn't have to do anything. The burden rests on the people, on the prosecution. If after the prosecution puts on their case, they haven't met that burden, then we don't expect the defense to go any farther. The defense doesn't need to put on a case where they haven't even proved it beyond a reasonable doubt. Now, you're saying to yourself, well, isn't that the jury's question? It is. But if the evidence is so insufficient that the judge can clearly see at that point that there is no reason for this to go any further, the judge does have the power to grant this. It is rarely done because judges don't like to take things out of the hands of the jury. They don't like to take things, they don't like to usurp the jury's role. But in rare instances where the case is just so hot garbage, they're going to do that. And because of that, every single defendant will make this motion. Usually it's after the prosecution's case, because they need to preserve that issue too. Because if on appeal, they want to second guess the judge's decision on that, they have to make this motion. Can I take a moment to brag about myself? I have been granted a judgment of acquittal after the prosecution's case, in a case that I handled as a defense attorney, where the prosecution's case was such a dumpster fire that we did ask the judge to grant the in California, we call it an 1118 motion, and the judge did grant it. So that is a feather I place firmly in my cap, and I'm very happy with. But to your point, Lori, I don't think it's overused at all. I think it's a natural function of our system. It drives home the point of presumption of innocence and burden of proof always remaining on the people. And if you haven't proven your case after the prosecution puts on their case, and that is so abundantly clear that the judge is willing to step in, then this gives the judge the ability to do that. But you're never going to see it. It's incredibly rare, because it usually has to do with a case that the wheels have come off. Something was wrong. Ms. Wildside says, did that shock you? It did shock me. I mean, because I've never seen it. I had never personally experienced it until it happened to me. It's usually either a case that never should have been filed or a case that really fell apart during the prosecution's case. And that's what happened on our case. Under some robust and vociferous cross-examination from the defense attorney, a lot of these witnesses did not hold up, and the judge at the end of the day realized this case is not going anywhere, and I'm not even going to waste the jurors' time to make them decide this thing. I'm going to decide. Which, by the way, the judges have the ability to do that. This is not the first time. At a prelim, if you don't have enough evidence, the judge can dismiss the case. Again, incredibly rare. Again, something I've also experienced. Not to shine my own, polish my own accolades here, but it is a situation that another situation. If at prelim they cannot reach that burden, a judge can dismiss it there. There are opportunities for a judge to do that. Canoni's Baloney, my favorite name on YouTube, says, Happy Father's Day. Thanks for doing Sunday Fun Day today. I missed you all last week. It didn't feel like a Sunday at all. It didn't. Something felt off, so I'm glad that we're all back here again. Thank you so much, Coney's Baloney. Let's keep it moving along here. All right. Great question, though. Lori from Bolivar.
Hi, Josh. This is Arlene, and I am curious to know, do you think Donna Adelson's trial will now be delayed? That's the wonderful news that Judge Everett will still be on the case. Excellent. Happy to hear that. But do you think that the trial itself will still or could be delayed? Interested in knowing. Thank you.
Thank you so much, Arlene. Arlene, you didn't give us your location. You gave us a wonderful question, but we didn't hear where you were from. So unfortunately, we hope you are on planet Earth, but we don't know where. You're asking about Donna Adelson, and will her trial be delayed? The judge is staying on the case. I'm going to plug a Wednesday night live that we did with Joel Waldman from Surviving the Survivor. I know there's a lot of big Surviving the Survivor fans watching this morning. And Joel and I sat down and talked about this exact issue. Was it last week? Was it just earlier this week? Yeah, just earlier this week. That's how fried my brain is. But we talked a lot about this, and we talked about what's next for Donna and your question of, is the trial going to be delayed? Here is my thoughts on it. I don't think that it will, unless something extraordinary happens with her attorneys. The accusations that were made in the affidavits to secure the warrants on Harvey's phone, Donna's husband, made allegations that there was collusion between Donna's attorneys and Donna to facilitate illegal phone calls. If that is true, and the investigators get to the bottom of that and present that in court or to the prosecutors, there could be a problem with them remaining on the case, because then they would have committed crimes. And if that's true, they may get removed from the case. And in this nightmare scenario, which I don't think will happen, and I sure hope won't happen, you could get a delay if the judge has to remove these attorneys. Now, that all being said, none of that has been proven. It's all just allegations. It could be wrong. It could be misunderstandings. And no one has ever said that that's going to happen. And no one has ever requested that. I'm just saying, if there's anything that's going to delay this trial at this point, which has already been delayed several times, I think the judge wants to get it going. I think it could be something cataclysmic like that, like the attorneys actually getting removed from the case. But we hope that that is not true. If you want to know more details, check out that Wednesday night live. We had a really fun time. It's always fun to have Joel on. It's always fun to have him on if he lets me have a word in edgewise. And every once in a while, he's kind enough to do that. But he's fantastic and a good friend. All right, let's keep it going. Thank you so much, Arlene, from somewhere on planet Earth.
Hi, Josh and the team at Courtroom Confidential. It's Sue from New Zealand calling. I've got another question for you for this week. I found myself, while I was doing some washing, thinking about Melody Farris, probably because she won't be doing any washing. I don't know why I was thinking about her. Clearly, I need better hobbies. Anyway, I was thinking about the dramatic way she spoke at her sentencing and wondered whether that ever happens in other court cases, or was it because it was a televised trial and we're not used to that she spoke like that? Or do you see that often? Do people get up and point the finger at other people who they may believe committed the crime? It was just quite dramatic, and I wondered whether that happens at all, or whether it was just an unusual thing. And also, I just wondered too whether her impassionate speech and the way she allocuted had any influence on the judge. Probably because I was expecting her to receive life without the possibility of parole, whereas she was actually given life with the possibility of parole. So I was wondering whether that impassionate speech like that, in your opinion, did you think it made a difference to the sentencing judge? Yeah, she was quite a character, that Melody. Now I need to think about something else.
Thank you so much, Sue from New Zealand. She's referencing the Melody Farris case. First of all, let's put New Zealand on the map. Thank you to all our New Zealand listeners and followers. Melody was accused of and convicted of killing her husband, Gary Farris. This was the fire pit case. Really fascinating case. And in the course of it, part of her defense was accusing her son of being the one who actually committed the murder. And her defense team kind of jumped all in on that idea, trying to throw suspicion at the son. And a lot of people kind of lost their minds. How horrible of a person are you to not only kill your husband, but then try to put your son in prison for the whole thing? Well, you're the same kind of person that would kill somebody. Is probably that horrible type of a person. It was a wild trial, says Canoni's Baloney. I agree with that. And then she did this, and I'm going to show you just a bit of it. It was a long, long speech that she gave, but we don't need to watch the entire thing, but we can watch some of it here.
I have waited for years to make this statement to everyone. I want the world to know who did this. I have always heard that the courtroom is the last place you're going to get the truth. And has that ever been proven to be the truth in this case? Not only did I not do this, I know who did. I know Scott killed his father. He took my husband, the father of Chris, Emily, and Amanda. He took Big Daddy from our grandchildren, Ella, Addison, Olivia, Jax, and James. 3 of them who never got to know Gary. Scott, this is unforgivable. Scott, I have spent an entire life of loving and protecting you, but this I refuse to cover for you. Mom.
Okay, I don't want to play the whole thing because this lady, we need to forget about her. But can we first? Somebody needs to give an award to whoever the cameramen were inside of that courtroom. I mean, the producer and the shot back and forth reaction shot with the sun perfectly timed. So good. So good. Yeah, there she is, tearfully accusing her son, who's sitting in court, of being the murderer in this whole case. I mean, she could have said, listen, I am not responsible. There is somebody else responsible, but she wanted to take this moment to name names, and it was wild. It was absolutely crazy. So thank you, Sue, for reminding us all of this. Your question was, is this common? Absolutely not. This kind of stuff never happens. I've seen defendants make kind of, I'm innocent, and they kind of have their moment and everybody kind of ignores it. I have never seen something like this. It does happen, but it is not common at all. And then to your next question, does it make a difference with the judge? If anything, I think it would make the judge less inclined to be merciful if the judge even has that kind. Usually these judges, by the way, we act like these sentencing hearings, the judge is making a big judgment call. Many times they're restricted by sentencing guidelines. Sometimes not so much, but many times they're restricted by sentencing guidelines, and it could already be just predetermined what she's going to get. But I don't think the judges, they realize that you have an incredibly emotional person. I'm sure he's probably a little more forgiving of what she's saying, but he's also not going to buy it. And he's also not going to view that as somebody taking responsibility and who probably should be shown some leniency. So I don't think it works in her favor. I would have said this sounds like the words of a person going in for LWOP, for life without parole, because they've got nothing to lose. So it's like, what do I care? I'm going to burn the whole world down with me. I'm an awful, awful human being, and everybody else might as well be miserable along with me. I'm my favorite part in all of that was the son. And when he goes, seriously? And then he starts doing this thing like, you got to cut this lady off. So good. So awful. Shouldn't be laughing about it, but so incredibly entertaining. But what I will say is, on top of the drama and the TV of it, very short-sighted, by the way, because if she is going to, decades down the road, be eligible for parole, this ain't going to help her. Like, part of getting paroled is the idea of accepting responsibility and realizing the damage that you've done. And with a statement like this, they're not going to look too friendly on that, though I doubt she's, got a chance of being paroled before she meets her end in prison anyways. But thank you, Sue from New Zealand, for reminding us of that one. It was pretty fantastic. Blessed in Texas, thank you so much for the super chat. Says, Josh, I appreciate your answer. I'll double Jeopardy as well. As I question, I pondered it myself. My conclusion, his faking his death is new evidence. So yes, she can be retried if she actually does kill him. Love that we're having this conversation, Blessed in Texas. You're thinking about it just as long as I was thinking about it. I'm going to push back on you a little bit, though. I appreciate your comment. Here's the thing, though. New evidence can't just undo double jeopardy. I mean, that's the whole problem with it, is if you lose as a prosecutor, something like finding the murder weapon, something like all of a sudden a witness comes forward to say that person confessed to me. So sorry, so sad. You cannot say, hey, by the way, our case got infinitely better since this person was convicted, and say, I want to retry this person again. But it is new evidence in the sense that it exonerates her of the previous crime. So that's why I'm saying, I think the way the prosecutors would treat this as, let's keep this lady arrested. Let's vacate and exonerate her of the prior murder, which she was wrongfully convicted for. So sorry about that, lady. And now let's try you for this brand new murder. I feel like we could have an entire episode just on this. Maybe we should start doing a whole series on could it happen or not, and just pick out the most ridiculous of courtroom dramas throughout the ages. I will say, I'm usually very forgiving of like courtroom drama type stuff, but there was a courtroom scene in this movie in particular where I nearly wanted to throw something at the television. It was like, you could tell that whatever consultant they had never set foot inside a courtroom, if they even had a consultant, or the consultant was going red in the face, telling them that stuff wouldn't happen. They were like, we don't care. This makes for good drama. Anyhow, it's putting all of that aside and suspending your disbelief. It is a very entertaining film. Yeah, I like that idea. Write that down, somebody. Tiffany, write that down. That might be a new series we're putting together. All right. let's keep it rolling here. And now I've messed up everything, so I gotta redo what I'm doing. Hold on, give me a second. All right.
Hey there, Josh and the CC team. My name is JD. I'm in Denver. Longtime listener, first time caller. I dove into the true crime realm at the beginning of COVID and can't seem to leave the pool. First, can you explain why it's such an issue for an expert witness to be overly looking at their notes or computer or watch during their testimony on the stand? I realized that I definitely seem to trust them more when they can confidently respond without referring to their notes. But it seems like there's an actual legal rule or reason or expectation that they're not supposed to abuse that during their testimony. So please do tell. And second, I've continually appreciated not only your channel, but your input on other people's channels as well. I especially get tickled when you get so tickled interacting with your members. Yet with like a calming and positive energy. You just easily impart answers and understanding to our questions with, I don't know, the simplicity and grace. And no matter how ugly the case or random our questions. So I guess, oops, I got cut off right before I got to finish by saying, thank you. Thank you, thank you, thank you. Cheers.
Oh, JD, that was very kind of you. That makes me feel very nice. Those are very, very nice words, and I appreciate you saying that. And that's what we try our best to do here, is to be objective and be fun and be inclusive of everybody's opinions. So thank you. I appreciate you. Denver, Colorado. By the way, Denver, Colorado will be the host city of CrimeCon coming up this year, which you may see some familiar faces there. So stay tuned. Anyhow, your question is about experts looking at their notes. I like this because these are some of those things that sometimes I take for granted that people appreciate and understand and know what's going on. And it is important to talk about these things sometimes. The answer is yes, there is a reason for it. People, when they are testifying, are supposed to be testifying based upon their memory and their memory only. That is why the idea of refreshing memory is such a big issue. When you're asking a witness on the stand, and we see this a lot in cases that we've been following closely, they will say something to them along the lines of, a person will say, I can't recall. And then you say, would it refresh your memory if I showed you your police report? Yes, it would. And then you go up and you show them the police report or your prior transcript, your prior testimony. You go up and you show them the testimony. And then they're supposed to say, the way this is supposed to work is to say, did that refresh your memory? Yes. What did you tell the police? I told them the guy in the black hat killed the other guy. Now, here's the problem that bothers me. It's supposed to be refreshing their memory of the event, not of what they told police or not of what they just read seconds ago. Usually that's the way it seems to go, is I said this thing and you're reminding me I said this thing and I don't even remember saying this thing, but I'm reading that I said this thing. And so I'm telling you now that's what I said. But the way it's supposed to go is, oh, yes, that refreshes my memory now of what I said at a prior occasion. What I would love to see from a witness one day is them to show them the transcript and the attorney goes, now, does that refresh your memory? And them go, no, still doesn't. So as I sit here right now, can't remember. And then to see the attorney sweat bullets trying to figure out how to handle that situation. So that all being said, my point is they are supposed to be testifying from memory when they're on the stand. Same goes for experts. They're supposed to be testifying from what's in their head and their memory. Now, with an expert and all of this complicated detail and specifics that you want them to get into and lengthy reports that they've compiled and facts and figures, they can't possibly keep that in their head. So they're constantly asking if they can refer back to their notes. I agree with you. I think it's kind of a weird, stupid formality. And both sides have seen the report. I would not have a problem if, and some judges do this, they tell the expert, you can freely refer to your report. And then we don't do this back and forth thing. And then every time they're asked a question, they just look for it where it's in their report and they give the answer. But some judges don't, and they make them go through this kind of awkward charade every single time. May I refer to my report? Yes, you can. Court's permission, blah, blah, blah. Is your memory reflected? Yes, it is. It was, 42 gigawatts, whatever the heck it is that they were asking the question about. But that's where it all comes from. JD, thank you so much for being a follower and supporter. And thank you for working up the courage to finally be a caller and ask us that question. And I love that question. And I think it helped a lot of us understand more about what's going on in court. And thank you so much for the kind words. Appreciate you. All right. Where are we going to next here? Where are we fueling up the jet and heading to?
Hi, Josh. This is Simone from Manchester, UK. Absolutely love the show. It's just great. Love everything about it. I often miss the lives, but I'm always not far behind in the background. So something you said last week, I always think this. Going off what you said about you tell your lawyer everything. Do you really? I'm in shock. So if I tell you, Josh, I murdered somebody, you can go in the courtroom and try to lie for me? Can you actually say I didn't do it, or do you have to find a way to say why? I never knew that. I thought you had to convince your lawyer first. Just shows you how much I know. I'd make a rubbish murderer. Thank God. Bye.
Oh, Simone, I love that. Simone calling from Manchester, UK. Thank you so much. I love this question. Yes, tell your lawyer everything, Simone. I love how you say that you would make a rubbish murderer. I hope there are other reasons beyond your trust of your attorney that would make for you being a bad murderer. But yes, tell your lawyer everything for a couple of reasons. One, your lawyer is probably the only person on the face of the earth that has the rock solid protection of not telling what you told them. So, I cannot think of another privilege that is more closely guarded than the attorney-client privilege. So if you got a body in the trunk, tell your lawyer and don't tell anybody else. But then you bring up an interesting point of, can my lawyer then go into court and lie for me? I like the way you put that, lie for you. Well, you will hear most attorneys say, absolutely, that's their whole job. They have to zealously represent their clients. Well, yes and no. First of all, lawyers are not supposed to perpetrate a fraud upon the court, right? So lawyers should not be personally saying things to a judge, to a jury, that they know are in fact provably false. Okay. And that's a very specific term I'm using there. Provably false. If I'm trying to think of something that would be so provably false, I don't know. The sun rose in the east, whatever it is. But my client has never been to Egypt. And you're arguing that to the judge, and you've in fact had dinner with your client in Cairo, that's problematic. Now you are saying something provably false to the court, okay? That is why we get this question every once in a while about people testifying in the narrative form. That attorney is not going to endorse the perjury about to take place from their own client. So they're going to allow them to testify, but they're just not going to play a role in that and allow the client to say whatever they want to say without the attorney getting involved. The other thing you can't do as an attorney is vouch up for your client. Ladies and gentlemen of the jury, I know my client is innocent. I know my client did not do this. That's vouching. That's you personally saying something to the jurors. But everything short of those is kind of fair game, and it's kind of expected. And there's a lot of leeway given to defense attorneys to argue, because the concept is going back to presumed innocent and burden of proof. For the most part, attorneys are making the argument that this cannot be proven. My client is not guilty in the sense of not guilty beyond a reasonable doubt. In this, not in the sense of provably factually innocent, but in the sense of not guilty for the purposes of why we're standing here. And do some attorneys go a little bit farther than that and seem to be a little more explicit in their arguments? Sure. Are they ever going to get in trouble for that? No. But rest assured, Simone, if you do decide to get into the murder business, and I strongly advise that you don't, please tell your attorney everything, and rest assured that no matter what you tell your attorney, they will go into court and advocate zealously on your behalf and not dime you out because you happen to confess to them that there's a body in the trunk. So, as a defense attorney, and thank you so much, Kay Schmidt, for becoming a new member. As a defense attorney, I will tell you, it's easier for me to do my job when I've got my client telling me everything. But when my client is trying to convince me of their own innocence, that's the only thing that actually leads to problems. Thank you, Simone. You're fantastic. I love that question. Blessed in Texas also became a member. Thank you so much, Blessed in Texas. Appreciate you. All right, let's keep it rolling. I love this. Are we having a good time? Everybody enjoying themselves? You having a good Sunday fun day and a good Father's Day? I hope so.
Hello, Josh, mods, and Courtroom Confidential people. I'm wondering what the jury is going to think about the invisible trooper Proctor, because both sides are reluctant to call him to the stand. This is Sally. My screen name is Twubble, and I am in Buellton with no longer Pea Soup Andersons. Have a good day.
Sally from Buellton, California, where there is no longer Pea Soup Andersons. Buellton, not that far away from where I am headquartered. Buellton on the way to Santa Barbara. Buellton, a town that I drove through many, many times in my youth and would always stop at Anderson's Pea Soup, and it is a tragedy. They closed in January of last year, and it's very sad. For those who don't know about Anderson's Pea Soup, it is one of these little restaurants that was like, if you are taking a road trip, that was your rest stop. If you're on your way to Northern California from Southern California, that's one of the places you're stopping. And they were famous for their split pea soup. And you're thinking to yourself, I've never in my life thought, boy, I got to pull over to get me a bowl of split pea soup. Well, then you haven't had Anderson's. It really was something else. And it really was, I don't know, just kind of comfort food on a different level. Ms. Wildside says, yeah, no more Anderson. I think there's still a location open, and I should have looked this up, but I know the Buellton location did close. And it's really sad. That's too bad. It was a great spot. But thank you, Sally, for calling from Buellton and reminding us of that. But I don't think that was the entire point of your question. You're asking about Karen Reed and what will the jurors think of missing Trooper Proctor? Great question. Great question. You know, I could see this playing both ways. I could see them viewing him as this boogeyman that was obviously being hidden by the prosecution and therefore must have been far more sinister than they can imagine. I could also see them saying it's kind of a mystery and I don't fully get it. Keep in mind, these jurors are supposed to have no idea about the first case and who this bald man is and what he did and all of that. Now, they know about his text messages, but they didn't see him on the stand. I don't think he became the villain that he played in the last trial. So a lot of them could be going, I don't know. It doesn't make much of a difference to me. I don't know what that has to do with anything. He sent a bunch of kind of ugly text messages, but I don't know how that plays a role in what we're doing. And this goes back to, what we had talked about this a little bit earlier. Why didn't the defense call him? And I think they seriously contemplated that disadvantage of not being able to cross-examine him. By the way, bear in mind, too, you cannot call someone to the stand just to impeach their character, right? Like, you have to have a legitimate reason for calling this person to the stand, and calling them to the stand just so that you can talk about their text messages and what a horrible person they are and why they got fired and everything else. Not something that's going to fly with the court. And I think, too, honestly, I think the defense thought this guy's such a wild card and there are landmines out there and we don't want him going rogue. When you're on cross-examination, you can ask yes or no questions. You never went inside the house, correct? Correct. And if he tries to go off rail and say, well, the reason why, non-responsive, not what I asked. You never went inside the house, correct? No. You never interviewed anyone inside of that house that day, did you? Correct? Correct. That's cross-examination. But if you're on direct and you're saying something like, what did you do next? Well, I did such and such. Did you go inside the house? No, I didn't. And somehow the issue of why didn't you go inside the house? Why didn't you interview those people in this loosey-goosey world of direct examination? And he starts to say, well, because I saw a bunch of text messages on your client's phone where she was texting her attorney or she was texting her father and blah, 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 blah. You could see where a bunch of stuff the defense had litigated heavily about might become an issue here. And they don't want, this gentleman blowing up their entire case. So I think everybody just thought, we got the dirt in we wanted about Proctor. Let's not bring a live grenade into court and play hot potato with it. So great question though. Sally, we'll see how the jurors view this guy. I don't think they will view him as negatively as the first round of jurors may have. Redondo Beach, so good to hear from you. I am filing a writ of review of fraud in the court of DCFS in Los Angeles County and fraud on the court jurors. Good luck with that. Hope that all works out well for you. I know that you're dealing with a lot of issues here in Los Angeles, and I know what a absolute nightmare it can be. So thank you so much for the super chat and sharing that with us. Let's keep things rolling along here.
Hi, Josh. This is Mitch Woodside, a fellow Grizzly from San Jose, California. My question relates to cameras in the courtroom. I think it's the judge that allows or disallows cameras in the courtroom. But why do we never see cameras in the courtroom in New York and very rarely in California? Is it possible that will change? And how does it change? I appreciate your channel and your time. Have a great week.
Thank you so much, Mitch from San Jose, California. Appreciate you putting you on the map. I'm sure you're familiar with Anderson's Pea Soup in Buellton, or where it used to be, if you've ever had to make that road trip from San Jose down to Los Angeles. Did anybody there was a Solvang location. Is the Solvang one still open? Now I'm thinking about is Pea Soup. Anyhow, Great question. Why does New York not show us trials? Why are they doing this to us? Do you know that the Rex Heuermann Gilgo Beach serial killer case will not be televised? Isn't that awful? Not a case of such high importance and magnitude and intrigue, and we're not going to be able to watch it. Well, you need to speak to your legislator in New York people. That is because there is a law, New York Civil Rights Law number 52, explicitly says no recording in courtrooms of any kind, which is fascinating to me in this day and age. And they're one of only a few states to have a blanket ban like that. California does not have a ban. California does televise. I mean, we saw Cementelli recently was televised. But what we didn't see was Harvey Weinstein. And the reason for that, True Crime with the Sarge. Hey, hello, my friend. Good to see you. Always appreciate you stopping by. You're in New York. Tell somebody in New York to change the laws and allow cameras in the courtroom. California does not have a ban. California allows it to be up to the respective judges, and some judges are just more inclined to do it than others. But in a case like Harvey Weinstein was not televised. That usually comes down to the fact that you're the subject matter. And when you're dealing with, sexual assault type cases, usually judges are less inclined to allow cameras into courtroom. It has to do with the parties. How much are they objecting to the whole thing? The official position from the LA District Attorney's Office is they have no position. So if the attorney is really objecting to it, sometimes the judge won't allow it. But I've seen judges allow it even when the attorney does object to it. I've had trials of mine televised over defense objection. But most states allow for it. Most states allow it to be up to the judge's discretion. And New York does not, along with the federal courts. Sean Diddy Combs is on trial, and we haven't seen one image from inside. They're keeping these courtroom illustrators employed. Again, it's a federal rule. Talk to Chief Justice Roberts about that. I think it's ridiculous. I don't think we live in a world anymore where cameras in the courtroom are going to be so outrageously affecting the trial that we can't do it in a fair way. The Sarge says in New York, the judge could still use cameras if they wish. They just don't. Is that right? I thought it was I looked it up and I thought it was an absolute rule, but I'm going to defer to you if you're saying I'm wrong on that. Maybe they can maybe there's an exception to the rule that they can employ. I don't know. But the research I had done said that there was actually a law in New York, but I could be wrong. And if anybody's going to tell me wrong, it's the Sarge. I will take my lickings from the Sarge. Linda Pisatoro says, hey, Josh, the other Anderson is in Santanella watching from Rhode Island. Well, thank you so much for that. We're taking a road trip, Tiff, to Santanella. They don't televise Luigi Mangione hearings. Didn't they televise a Luigi Mangione hearing? That's a really good point. Yeah, they did. Yeah, they did. And that was in state court. They didn't do the federal one. Great point, Afton. I don't know. I know that Heuermann is not supposed to be televised, and we haven't seen anything from inside the hearings on that. Now I don't know anymore. Sarge, you should have been my phone a friend. I should have got a direct answer from you. Flora Paris says, driving up to Pasadena right now, but sending a reminder that you need an update in the case of the lawyer and the inaccurate truck contract if you haven't already covered it. Thank you, Flora Paris. Yes. I think it was Wednesday. I told you all that I bought a new truck. Very happy with it. I got an incredible deal. I was thrilled. And then I got a call from the dealership telling me that, hey, they made an error in my favor. In other words, they missed something. And because they missed it, I'd signed all their paperwork. They explained everything to me. I'm signing documents. And they said that somehow they made some error and that error favored me, and they would then like to cancel the contract and renegotiate it with me so that I would have to pay more money. And I let out a few expletives and said, I cannot believe this phone call is actually taking place. And I said, you got to be kidding me. This is not the way contracts work. Somebody asked me, did they know you were a lawyer? I said, they're about to find out. I tried to be very level-headed and say, listen, I'm a returning customer. You guys made an error. I appreciate that mistakes take place. If I make a mistake, I deal with it. You guys made a mistake. I think you should deal with it. I'm not renegotiating this thing. This is ridiculous to me. Anyhow, long story short, after our Wednesday night live, I called them back and we worked it all out. And I don't have to pay a dime more. And I'm very happy with my truck. And so I will still highly recommend that dealership. I don't want to name their names because I don't want anybody coming after them. But I'm very happy with them. And I told them they have now earned themselves a returning customer for life. And I appreciate them acknowledging the mistake that they made. And the one thing the guy did say to me, he's like, by the way, this is probably the best deal on a truck we will give out this year. So well done. And I said, thank you. I appreciate that. So very happy about that. And thank you for asking for the update. I didn't see that last one. I missed it. All right. Joshua used adult word. Yes, he did. The kids had to have some earmuffs while I used some adult words with the dealership. Anyhow, I guess we didn't get the cleanest answer for you, Mitch. I will try to do some better research and find out what exactly is going on in New York, but that was my understanding. Anyhow.
Hi, it's Misbehaving from South Wales again, although I do live in Nottingham, Robin Hood country. So I've got a quick little question regarding to expert testimony. So I'll take Dr. Welcher as an example. If in the Karen Reid trial he ran 10 crash test dummies against the Lexus, but only one actually was in the Commonwealth theory, would he have to hand over those nine failed tests to the defense so they can argue his basically his experiments? If this is true, do you think this is why none of these experiments were actually done? Thank you. Love the show. Bye.
Misbehaving from Nottingham, England. Let's put you on the map where Robin Hood is from. Thank you so much for calling in. I love this question. This is a great question. Because it gets to the kind of heart of and strategic concept behind experts and what the prosecution can do and can't do and what the defense can and can't do. So in the Karen Reid trial for the Commonwealth, they called Dr. Judson Welcher. And the question is, would he have had to, if he performed a bunch of experiments like the defense did try to kind of reconstruct a live experiment of what the Commonwealth's theory of the case was and whether or not certain things could take place. The prosecution didn't do that so much. You remember the prosecution's recreation was with the blue paint and the car moving at a much slower speed. And the prosecution was much more, I think, trying to drive home the point of, would the arm even line up with the tail light if this had in fact taken place? But Misbehaving's question is, would they have had to turn over the failed experiments? If they had done this, and let's say they were trying to question the theory of whether or not the taillight could be broken, and they failed, and then one time they succeeded, are they allowed to only bring in the successful test and not bring in the failed test? The answer is 100% no. They have to bring in everything. And that is likely why they didn't perform experiments, because again, it's this kind of this concept of proving a negative, right? You are trying to prove the possibility of something happening. And if you do it 10 times and it happens once, you've proven that it's possible, but you've also proven how unlikely it is. And that is not a concept the Commonwealth likely wanted to introduce to jurors, because their theory is that this was the time that it happened. The reason they have to turn that over is because it's exculpatory evidence, and they have to turn over all evidence. The prosecution cannot pick and choose. Now, the defense usually can, but I believe that the rules in Massachusetts are not so much that the defense has to turn over everything as well. They have different discovery obligations and rules in Massachusetts than I'm used to. In California, you can, and it is very common for defense attorneys to employ experts, find out that that expert's opinion is not so favorable to their cause, not use that person, bury that report, not turn that over, because there isn't the same obligation of providing exculpatory evidence. The mutual discovery rules only apply to the defense as far as what the defense is going to use. So if the defense is not going to use something, then that's considered part of their attorney work product, and they don't have to turn that over. In Massachusetts, I believe it worked differently, and they did have to turn over whatever they did. Not Sarah Lee 358 says, I'm still fascinated with Josh using usurp in a sentence. I'm definitely my new word of the day. Oh boy, here we go. Especially since Alessi isn't in court right now. I'm glad I could help out with that. Now I'm gonna be super self-conscious of it. Anyhow, and which begs the question to me, and I know this isn't what exactly you were asking, Miss Behaven, but it begs the question to me as to why the defense did these experiments. In my view, if I'm the defense attorneys, and believe me, I am not trying to question these defense attorneys. They did an incredible job. They're very good attorneys. I'm not trying to say I'm smarter or better than them, but I was confused by the idea that they did these reconstructions. Because here's where things are. If you're the defense, you can argue facts, figures, science, physics, and have your experts say, not possible, never gonna be possible. The force, the load, the whatever, the diagrams, the math, whatever you say, not gonna happen. Never going to have a situation where a car going the speed that the Commonwealth says could burst the taillight on somebody's arm, okay? But when you perform the experiment to try to prove that, what happens when you prove it can happen, which they did? Now, I realize it was at a greater speed, and I realize that the argument is then that, oh, well, then his arm would have been obliterated. I get all of that. But if you're trying to prove the idea that something is impossible and you show jurors a situation where it is possible, I don't understand the strategy behind that, because now you're arguing back against your own experiment, right? I mean, here's the thing. Unless they knew they could drive that car at 100 miles an hour, and it would never bust that taillight, you now have presented to the jurors an idea of the possibility of something, whereas before they may have just believed it was not possible. I don't know. True Crime with the Sarge. Hello, my friend. Thank you so much. Says, I love the Q&A and would steal the idea. Please do. And I look forward to submitting my questions to you. I appreciate all your support, my friend, and good to see you here this morning. All right. Anyhow, that was just one of the things to me about this whole experiment. And to me, if you're the defense, you want people with more questions than answers. And when you start providing to them answers, and those answers may be unfavorable, now you're in a position where you're arguing against yourself. So anyhow, great question. Appreciate you misbehaving. Thank you for calling in from Nottingham. I hope I made sense with all of that. I know I kind of went off on a tangent. All right. Let us keep it rolling along here.
Hey Josh, it's Willow giving you another call. My question this week is personal and probably a little bit silly, but I just wanted to know how you find the time in a day to do everything that you do. So between putting on the show, doing your research to answer all of our questions and research on what's going on every week to do your weekly roundups, not to mention connecting with all of these other people to put together, your phone a friend segments, doing interviews with other people. I'm sure that's got to be time consuming. In addition to that, being an actual lawyer as well. I know you've got a family and everything. I can't even figure out where to fit in my schedule to get the laundry done half of the time. So I'm just curious, do you not watch TV? Do you only sleep 2 hours a night? I'm just really curious because you seem to always be very productive in everything that you're doing, and you seem like a person that's got it together. So just a personal question, how do you maximize your time in the way that you do to get everything done? Thanks again to everybody that puts together the show, and thank you for your very precious time.
Oh, Willow, that is so kind of you. That really touches me. That really warms my heart and makes me feel good. I appreciate you saying that. First of all, York, Pennsylvania. I know from when you've called before, that's where you're calling from. So we're putting you on the map. I appreciate you saying such kind words. Where do I get the time? It's hard. We don't have much time. We are working really hard, and I don't use this as an opportunity to kind of complain or brag. I'm not complaining or bragging at all, but we are all working very hard, and I give all of the credit to Tiffany, my wife, for everything that she does. She works even harder than me on this, and to Kaylin, who we could not be doing this without. Her help. We call upon her at all hours of the day and on weekends, and continue to apologize to her every step of the way and say, you got to tell us when to stop because we'll never stop. And she just keeps on saying, no, I'm ready. Keep telling me, what do you got next for me? And this community is also incredible. I mean, the feedback and love that we get from all of you makes it well worth our time. Tiffany says everything's intentional. That's true. We try to make sure that we're not just kind of scatterbrained and doing a bunch of stuff that isn't moving the ball forward. What is our phrase, Tiffany? Oh, no, I'm going to mess it up. Be something or be normal, or what is it? be, you know what I'm saying. But I will tell you that it does get tough. The other day, our middle child, Riley, she's 2.5. She says to me, I had to go, I don't know what it was, go do a Wednesday night live or something. And she knows when I'm heading towards the off, be obsessed or be average. That's it. That's our mantra. Be obsessed or be average. But Riley stops me in my tracks and she goes, no work, Dada. No work, Dada. And then she wagged her little finger at me. And, that's tough. I mean, listen, we're working out of the house for most of this. So it's not like I'm going away to an office for hours a day, but we are putting in a lot of work. And that's because we really want this to work. Thank you so much, Emma, for the super sticker. We really do want this to take off and to, so that I can step away from kind of the other work that brings me away from the house, and we can put more into this community, and we can turn this little channel and little podcast and everything we're putting together into something much larger and have more people involved. And so Willow, thank you so much. I'm really, really appreciative of you saying that. I appreciate you, your encouragement and being part of the community, as well as to everybody who's here this morning. It is a lot of work, but I tell you, when you're doing something you love, you feel like you're not working. And that's absolutely how I feel. I feel tired, that's for sure, but I do not feel like I'm working. So thank you so much for that. Appreciate you guys. Appreciate you, Tiffany. Appreciate you, Kaylin. I see you. And everybody else. Oh, and all of our mods too. Afton and Sonia and Kathy. Thank you guys so much for everything that you do to make all of this possible. All right, let's keep it rolling along here.
Hi, Josh. This is Pam calling from Southeast Michigan. Quick question, and this has to do with Lori Daybell, or actually any defendant that chooses to defend themselves. As we all know, this week she showed up in court in a wheelchair, saying that she was sick. Obviously, it was very frustrating. Obviously, they had to reschedule, postpone. I think, very obviously frustrating for the judge and probably the prosecutor. My question is, what do you do in this instance? Is there any way that he can force her legal team, who is on standby, to take over? He did make mention of something about this initially before the Charles Vallow trial, that he will have her legal counsel step up and take over if necessary. So I'm not sure if something like that can happen, because otherwise they're at the mercy of Lori Daybell and whatever she feels she wants to do to throw herself a temper tantrum. That's it. Can't wait to listen on Sunday. Talk soon. Bye.
Thank you so much, Pam from Michigan. Appreciate the call. Appreciate you calling in, putting Michigan on the map. This is a great question about Lori Vallow Daybell. I'm going to start calling her Lori Daybell because I've had more than one person tell me, take that name Vallow out of her mouth and don't associate it with her, with everything that she's done to that family. Right. Clarence Darrow says, the man who represents himself has a fool for a client. Thank you for that, Joe. And it's absolutely true. And beyond that, she has no place representing herself, but you get what you want. And the reason for that is you have a constitutional right to it. There was a case called Ferretta versus California from 1975. This is a Supreme Court case, and it basically considered the exact concept of the question that you're asking. Is there a way that a judge can take away someone's right to represent themselves? And what the court felt in that case was, and this is a quote from that case that I love. I think it's really well done. It says, to deny a man in the exercise of his free choice the right to dispense with some of these safeguards, meaning your rights, is to imprison a man in his privileges and call it the Constitution. I love that. In other words, you have these rights. You have a Sixth Amendment right to counsel. You don't have a Sixth Amendment right to no counsel. You have a Sixth Amendment right to counsel. But the court felt that not viewing that as both a right and a right to waive that right is imprisoning that person in that right. And therefore, the idea of the Constitution is about giving freedoms and rights, not taking them away. And are you taking away a right by saying, no, you have a right to counsel? And I know I'm kind of being confusing here, but is the idea that you have a right to counsel going to be foisted upon you, or can you exercise your right to refuse that? And they felt that you could. So the case of Ferretta was a guy, by the way, accused of grand theft. This was not a murder case. And he wanted to represent himself. It was here in Los Angeles because he felt that the public defender's office was overwhelmed. And what I love about that is that even small cases can have big effect. This is not a big case. This guy was in and out of prison way before this ever made itself to the Supreme Court. But the issue was big enough for the court to take it on. And now we know what a Farris hearing is and a Farris right. The idea comes down to this. As long as you voluntarily, knowingly, and intelligently waive your right, you can waive that right. And a judge may have the discretion to deny that waiver, but only if it's because the judge finds that you are either not doing it voluntarily, knowingly, or intelligently. And yes, there's a lot of wiggle room in there. And that's why the judge questioned her so heavily about, does she know what a lawyer does? Does she know about evidence? Does she know about the charges and all of those things? But as long as you are able to prove to a judge that you are knowingly, voluntarily, and intelligently waiving that right, then you have a right to waive that right. And that's why she was able to represent herself here. So great question, Pam from Michigan. Garden Girl 9 says, thank you so much for the super chat. Enjoy size of our community while it lasts. It will explode in size. I have no doubt. I love your life plan if you can have one. I have 4 kids in 6 years. These busy times will be the best memories. Oh, Golden Girl, you're helping me out more than you even know. Yeah, we've got 3 who are under the age of 5, and every single one of them is starting to bark orders at me now. But we are just in the thick of loving them when they're little ones, and we decided what better time to take on an entirely new career. And I hope from your lips to God's ears that this whole thing does explode and that you're all along for the ride. So thank you very, very much. And thank you, Pam from Michigan, for asking the great question. All right.
Hi, Josh. This is Robin calling from Kennewick, Washington. More with a statement. You wanted to know about women following true crime. Now, I can't speak for all women, but myself, I want to know about the victims or victim. I want to know about their life, what their passions were, what their dreams were, what their families, had to say about them. I'm not interested in the person that committed the awful crime and how they're trying to, get away with doing whatever they did. And I think it's horrible how the media on the anniversaries of these crimes puts the perpetrator in the 5 minutes of fame again. It's the victims that need to be remembered. It was their lives that were taken short. But that's why I follow, Josh. I love everything that you do. Keep up the good work, and I hope everybody has a great day.
Thank you so much, Robin. What a kind thing to say again. Robin from Kennewick, Washington. Appreciate you, and we're putting Kennewick on the map. I couldn't agree with you more. I do, I think Robin's comment is coming out of a discussion that we had on a previous Sunday Funday about, true crime does seem to be a female dominated genre. And why is that? And many people have submitted different answers, and Robin's answer is one that we saw commonly, is that it's the idea about the stories of the victims and their story of survival or their story of remembrance, and not so much about being defendant oriented or centric. And you made me think of when I was a law clerk in the DA's office, one of the most highly respected and distinguished attorneys, prosecutors there, was a man by the name of John Monahan. He had the notorious or infamous whatever you want to call it, privilege or distinction of being, while he was a prosecutor, the person with most people on death row as he was a prosecutor. People that he had prosecuted and had been sentenced to death. In any case, He was a very, very good attorney, considered like a real badass in the office. He's since retired. I wish him well. I was able to be his law clerk on a couple of different cases that were death penalty cases. And I will say that, you know, putting aside, however, you guys, your personal feelings on the death penalty, I will say that in the time that I was a prosecutor, I had never seen a death penalty case sought in a case that I felt like didn't deserve it. In other words, every single case, and they put the DA's office, especially in Los Angeles, puts they have to go through a lot of committees before they're ever going to pursue something like the death penalty. And it is reserved for the worst of the worst of the worst. And I'm talking like the most heinous of crimes, stuff that we don't even want to talk about on this channel because it's so kind of horrific. You know, we're talking about multiple deaths of children or something like that, torture type deaths, things that are just the worst of the worst evil people. Anyhow, he would handle these cases, and he was a very good attorney. He was not what I would call like your Alan Jackson style of attorney. He was not like kind of super polished and kind of, you know, had this bigger than life sort of a personality, but he was a person. And what I realized his greatest skill was after watching him was when he was done, the jurors believed everything that came out of that man's mouth as if it were gospel. He had a trustworthiness about him and a no nonsense about him that just stuck with jurors. In any case, this is my long-winded way of getting back to your point about victims and defendants. He used to begin his closing arguments in the death penalty phase, in the penalty phase of a case, with this quote from a book. And I looked long and hard to try to find this. It's a true crime novel. And if anybody can find it, I will be very grateful. But it's a true crime novel. And in the opening paragraphs of either the preface or the introduction, it talks about this concept and it puts it very eloquently. And he would quote it. And it talks about the idea that when a crime is first committed, like a murder, that immediately our public consciousness goes towards the victim. We think about the tragedy of the loss of life, and we think about the tragedy of what that family is going through. And then we turn towards the trial, and it becomes still about the victim, but also now about this new player, this defendant, this other person, and whether or not they will be convicted. But as time goes by and decades pass, this natural kind of general consciousness begins to drift away from the victim, who is now dead and buried and perhaps forgotten by many, and towards the defendant, because they're still living and they're in prison, and this idea of what they're going through. And it is true. It is funny how when these cases come up decades later, we talk about the defendants and very little attention is given to the victim still, because the defendant is alive and with us and experiencing life. And we think about that. And that has always stuck with me. And he would always bring that up to really kind of recenter people on the idea of victims and the idea of never letting them be forgotten and never letting the case not be about them. And that's always stuck with me. And I looked long and hard for that quote, and I couldn't find it. But if you guys find it, you're fantastic. But that is, I think, an important part of why true crime is important to talk about and discuss, and why it is such a popular genre, is that people are concerned with that story. So thank you so much, Robin, for kind of recentering us on all of that. Really greatly appreciated. All right.
Josh, this is Andrea calling from Winston-Salem, North Carolina. And my question is, what challenges does a defense team face when preparing for dual trials, meaning one federal and one state for the same defendant, such as Luigi Mangione? Do they prepare separate cases for each or present the same evidence and findings for both? Also, what are your thoughts on the huge difference in timeframes in bringing a case to trial? For example, the Diddy trial and the Luigi trial, both being federal cases out of New York, Diddy got to trial in about 8 months, but Luigi's won't even be scheduled until December of this year. Anyway, thanks for your coverage on so many cases, and I'm so happy to see how quickly Courtroom Confidential is growing. Keep up the amazing work. Bye.
Thank you so much, Andrea, from Winston-Salem, North Carolina. I think that's the first time we've had Winston-Salem on the map, so appreciate you and appreciate the question. And it's a great question that I think a lot of people are wondering about, is what do you do in these situations like Luigi Mangione, like Sean Diddy Combs, where there may be these kind of dual prosecutions between the state and the feds? I don't actually think... I could be wrong. I don't think Sean Combs has state charges against him. I know he's got certainly federal charges, and that doesn't mean that they're stopping the states from pursuing charges against him if they want to. But I know for sure Luigi Mangione has dual prosecution going on, and that's raised a lot of questions with people because they're going, what's going on here? I thought Double Jeopardy. We just talked about that. It's a great movie from 1999 starring Ashley Judd. You should check it out. How in the world could they be doing this, prosecuting him on both a state and federal level? Well, there is this idea of dual sovereignties, and the idea of the feds are very separate from and a different sovereignty from the states, and so therefore you can violate both laws, criminal laws from both sovereignties, and therefore they can both prosecute you. Usually this does not happen. In rare circumstances, it does happen. It's happening in the Luigi Mangione case. But another thing to keep in mind is that many times the elements between these charges are not exactly the same. So in the Luigi Mangione case, he's being prosecuted for murder with the act of terrorism on the state level, and on the federal level, it's murder with the use of a firearm. And so, yes, they're both murder. They're both murder of the same person, but there's different elements and therefore arguments to be made that they're not the same crime. But that wasn't so much your question. Your question was, how do the defense attorneys prepare for this? Well, first of all, it happens so rarely that it's not all that common of a thing. But the defense attorneys are probably not preparing all that much different. It's just kind of double the work as far as double the trial. But it's not like they have to dramatically change course as far as the arguments that they're going to present in both cases, or the witnesses that will be presented in both cases, or the strategy in both cases is likely going to be the same, because you're fighting the same charges in general. It's just in a different forum and with different rules as far as evidence. You're going to have slightly different evidence code rules, procedural rules on the state level as opposed to the federal level. But it's very, very unique. And I imagine what is happening more than anything is they're not even concerning themselves with the federal case right now, because that's going to follow the state case, and they're just concentrating on the state case. And I wouldn't be surprised, by the way, if he is convicted on the state level, that there's some sort of settlement on the federal level rather than going through an entire new trial. Your next question was, why do some trials take longer than others? And that was a good one, because a good comparison between Mangione and Diddy is they both are being prosecuted federally. Why is Sean Diddy Combs immediately starting trial? And why is Luigi Mangione taking their sweet time? Well, the reason for that is one of the few things the defendant actually controls is the clock. The defendant is the one who has a constitutional right to a speedy trial, but the defendant can waive that. It depends on the jurisdiction as to what they mean by speedy trial, but if the defendant is saying they want more time, the judge will give them more time. If the prosecution is saying they want more time, the judge says, sorry, they've got a constitutional right to a speedy trial. So what you have happening is Sean Combs, wealthy guy, never spent a day in jail, all of a sudden finds himself in this stinky, stinky jail and doesn't want to be there, and was willing to pay a king's ransom to get out. And the judge denies it. So he says, well, screw this. Give me my trial ASAP. And that's what's happening with him. Luigi Mangione, on the other hand, is, I think, less enthusiastic to go to trial as quickly, has waived time, and has the idea of these two things going on. So it's like, where's he going to go anyways? The federal case is going to follow the state case. So he's going to go to state court anyways. So he's going to prolong the federal case to put it out past that, just because of the way that it's working out. And he's looking at potentially the death penalty on the federal side. So that's going to be something that's going to take a long time too. They're going to give him all the time that he wants to prepare for that because he's defending himself against the death penalty. So the answer, in a short way and not a long-winded way, is the defendant controls the clock, and it really is up to them whether they want to get it going quickly or whether they want to get it going, take their time to prepare. The example I always think of is OJ. What people don't forget is that Nicole and Ron were killed, and it took less than a year for that trial to be had and the not guilty to come out. That is nearly unheard of. I mean, that was like a fast track situation because OJ was in custody and didn't waive time. I mean, he waived some time, but not years. Usually a case of that magnitude, seriousness, and celebrity involvement, you could see that easily taking a few years to go to trial. But the defendant controls the clock for the most part. Thank you so much, Andrea. Andrea from Winston-Salem. Appreciate you.
Hi, Josh. This is Gloria from Florida. I just wondered if we can assign a percentage to reasonable doubt. I always hear the prosecution bears the total burden, most of the burden, to prove their case, and beyond a reasonable doubt. Is that 70%? Is it 60? Is it 80? I suppose for some jurors it's 100. So I just had that question. I don't know if that's ever come up. Thank you. All righty. Bye.
Gloria from Florida, thank you so much. Let's put you on the map. Your question, has that ever come up? Gloria, you probably have stumbled upon the most highly contested issue in all of criminal law. Not only has it come up, but it comes up all the time, always. What the heck is reasonable doubt? When you're saying beyond a reasonable doubt, what does that mean? Preponderance of the evidence, we can tell you what that means. Preponderance of the evidence means just more likely than not. So you can talk about percentages. You can say if something is 50-50 and you add a feather to the other side, that's preponderance of the evidence. Just more likely than not. Reasonable doubt, though, you can't give a percentage to, and we would love to. This is one of the most highly debated and contested issues. And every single trial, they talk about what does that mean. And defense attorneys will get up and they'll talk about the burden of preponderance of the evidence. And then they'll talk about the burden of clear and convincing. Clear and convincing, this is me quoting a defense attorney here, your typical defense attorney. Clear and convincing is such a high standard that it is the standard used to decide whether or not children can be taken away from their parents in a custody dispute. That is clear and convincing evidence. And that standard, as high as it is not as high as the unattainable beyond a reasonable doubt. And that's the defense attorney. And then you get the prosecutor who comes up and tries to bring everything back down to earth and make it sound like reasonable doubt is really, really attainable. Well, the answer is no one's got a good handle on it, and we give them definitions like this. This is from the California jury instructions. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. So you'll hear prosecutors talk about this a lot. I can't possibly imagine everything that you could come up with in your head. But do you agree that we're not talking about imaginary doubts or every possible doubt, only reasonable doubts? And then we'll talk about this idea of an abiding conviction. What does that mean? That means something that you believe today, and when you wake up tomorrow and 5 years and 10 years and 20 years from now, you will feel as strongly about this as you do as you sit here right now. The federal rules, this is their definition for beyond a reasonable doubt. This is from Rule 6, Instruction 6.5. Proof beyond a reasonable doubt is proof that leaves you firmly convinced the defendant is guilty. It is not required that the government prove guilt beyond all possible doubt. A reasonable doubt is a doubt based upon reason and common sense, and it is not based purely on speculation. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. Do you feel any more clear about all of this stuff after hearing both of those instructions? And those instructions, by the way, have been litigated and gone over by judges and attorneys for decades and decades. And this is the best that they can come up with. And that's because it is a concept. It's not a hardline rule. It's an idea. And I think the best way that you can put it is it's something that you feel like if you were making a super important decision in your life that you could not take back, do you feel as comfortable about this decision you're about to make? And people I've heard say, well, it's like trying to decide the person you're going to marry. Well, probably more than that, because people get married and divorced, unfortunately, quite a bit. This is like the idea of, hey, this is important, and I'm going to do this. And I realize I can't ever take this back if I do this. And if you feel like comfortable enough to make that decision, then that's the decision you make. But that doesn't mean that you walk away with zero doubt in your head, because you can have possible doubts and imaginary doubts and lingering questions. But just as long as you feel that beyond a reasonable doubt, reasonable being the active word in that sentence, you feel comfortable in what's the decision you're making, then there's the decision you should make. Thank you so much, Gloria from Florida. Great question. This will be the thing that will be debated till the end of time in criminal law. Certainly something we can't figure out as we sit here today. All right, where are we heading to next? You guys having fun? I hope so. I am.
Josh, Adelson from Grand Haven, Michigan. Love listening to you guys on Sunday. I'm just wondering, for the prosecution and the defense, what are the rules about prepping witnesses? I would think you would want to prep them a lot. We always see that on TV. They do mock trials. They do a lot of practice, but the way Brennan seems to be talking to the witnesses in Karen Reed's case, it seems like you're not supposed to talk to your witnesses prior to testimony. I understand you're not supposed to talk to them after they've taken the stand, but I'm just not understanding that. So I'm wondering if you could explain that to us. Thank you. Bye-bye.
Allison, I know that was hard to hear, everybody, but I was able to hear it, and I'll fill you in. But this is Allison calling from Grand Haven, Michigan. First of all, let's put Grand Haven on the map, and thank Allison so much for taking the time to ask this question. And Allison asked a interesting question that we saw come up quite a bit in the Karen Reed trial. I will tell you, there's a few things that took place in this trial that are not typical. We talked a little bit about the idea of the reciprocal discovery obligations and how they're much more strict in Massachusetts than they are in other parts of the country. And this was another thing that is a little unique. There was what's called a sequestration order in place in this case, meaning that the judge had ordered that the attorneys could have no contact with the witnesses in preparation for this. And we saw them question, especially the experts, about this a few times. I know that it became a little bit of an issue with Dr. Marie Russell. She was asked about a conversation that she had with Bob Alessi happened to take place in the back of a limo. I thought the optics of that were probably not great for the defense. And that Alessi had told her if she's ever questioned that she should ask for the transcript of something that she said prior. And Brennan really jumped on that. And it was the idea that they should not have been talking at all about her testimony. You could talk to them about what kind of a ham sandwich they would like, but you cannot talk to them about their testimony or how to perform on their testimony. And he tried to make great hay with the idea that he had coached her to ask for a transcript. Now, the judge didn't lose her top about this whole thing. Was it a violation of the sequestration order? I suppose perhaps. The other time I think it came up was with Dr. Daniel Wolf. You guys all remember Dr. Dimples here. The idea that this was a big issue that he had spoken to and had communications with the defense from the first time around, and whether or not that what role that played as far as violations of sequestration orders. But the overall answer to your question is usually this is not the way it works. Usually you're allowed to talk to your witnesses all you want. You can sit down with and you should sit down with them. You should prepare them. You shouldn't coach them. You shouldn't tell them exactly what they should be testifying to, but you should tell them, this is the way things are going to work. You're going to be asked certain questions. This is how I want you to answer those questions. I would sit down with every single one of my witnesses and I would tell them, here's the ground rules. Never guess at a question that you're being asked. If you're guessing at anything or estimating, make sure everybody in the courtroom knows it. Make sure you understand the question. If you don't understand the question, tell them to ask it again. Make sure that you're answering the question and not some other question. Pay attention to the questions being asked. These types of things. I would tell them, I don't want you to argue. I don't want you to worry about the questions that the other side is asking you. I get to gut up and ask you more questions afterwards. And that's my job. Let me earn my money. Let me do my job. Your job is just to tell the truth. And that is all violations of what would have been the sequestration order in the Karen Reed case, but it's good practice as trial attorneys otherwise. But the reason it became an issue in this case, so the answer to your question, Allison, is you should prepare your witnesses. You should talk with them. Bearing in mind, though, that they can be asked about that. If you can ask a witness, did you speak to the prosecution? Did you speak to the defense attorneys? What did you say? There's no attorney-client privilege there. So all of that stuff is going to come out. And that's why I always made a point of telling witnesses, if you're asked, what did we talk about? I want you to tell them I told you to tell the truth, which is exactly what I'm telling you. And I would always enjoy that moment when it would happen in court. But different rules in the Karen Reed case. There was a order in place that they were to have no contact with the witnesses. And that's why both sides tried to make an issue of it if it appeared as though that had been violated, as if some sort of huge, violation of law had taken place, when in fact it was just an order in place by the judge. Great question, Allison. Appreciate you reminding us of that issue in that case. All right, guys, we're coming to the last few here.
Hey, Josh, this is Christopher, a.k.a. Johnny Knoxville, in the great state of North Carolina, Chapel Hill to be more specific. Anyway, so my question is, and I learned this the hard way through trying to get video footage or getting a police report or getting a 911 call released from my local police department. They told me I needed to go get a court order for this information or these documents. And to my understanding, you can't just get body camera footage in the state of North Carolina unless you're in the video. If you're not in the video, you have to go get a court order to get this stuff released. So if somebody calls in something on me, but I'm not in the video, and the police go and interview that person on body camera, I can't get that footage unless I get a court order. It just seems to me that that's in contradiction with the Freedom of Information Act. I thought the whole point of FOIA was to allow citizens to get a hold of government documents and government information much, much easier without having the burden of a court order. That just seems to me in contradiction. I would think somebody could challenge North Carolina's law on this to the Supreme Court and get that law thrown out and struck down. What do you think? Do you agree? Do you disagree? Do you not know because you're not a North Carolina attorney? Anyway, thank you. Have a great day.
So good to hear from you, my friend Christopher, aka Johnny Knoxville, calling from Chapel Hill, North Carolina. Let's put you on the map. Johnny, it sounds like you're up to trouble, and I absolutely love it. You are out there causing somebody grief, and I absolutely love it. And I wish you the best. So here's the answer to your question, and I hope this answers your question. Why can't you get this body cam footage? Why isn't this subject to FOIA? FOIA is, as Johnny explained, the Freedom of Information Act. FOIA is, by the way, you don't need like some sort of official FOIA document. You don't need to hire a FOIA lawyer. FOIA just stands for the idea that if you send written request to a government agency for information, it's highly favored, the idea that they have to turn that over. But as with anything, Johnny, there are exceptions, and the exceptions oftentimes leave lots of room for interpretation and lots of wiggle room. Here are some of the exceptions. One, anything dealing with national security. They're not going to turn that over. You cannot FOIA the nuclear submarine blueprints. Two, anything dealing with internal policies and practices. You cannot say to the LAPD or the North Carolina or the Chapel Hill PD, give me your policy manual on arrests. Privilege communications, attorney-client privilege, work product privilege, any kind of thing that would invoke some sort of privilege cannot be turned over. Anything that affects the privacy of other persons. And this might be the trouble you're running into. If you are asking for body cam footage that shows other people and therefore affecting their privacy, there may be some pushback on why you're trying to get that information when it's dealing with other people and they hold the privacy right of that thing. And then the catch-all, Johnny, is stuff that is compiled for law enforcement purposes. And that's why most police reports, most body cam footage, most anything done by the police that is being compiled for law enforcement purposes, they are going to hold on to strongly and not turn over. Even putting FOIA aside, as a defense attorney, I many times get clients who hire me before they've been arrested. Something has taken place. They believe that they're under investigation, but they have not been charged. Or they've been arrested and still not charged yet. They've been arrested and, a future court date is down the road. I cannot get those police reports. I cannot call, whatever local police department and say, you arrested my client. I want the report on that, because it's still protected as part of this law enforcement purposes, privacy privileged information. Victims can sometimes get that information, but not the defendant. Pardon me. Until that person is charged with an actual crime. Then it's part of discovery and then it gets turned over. But I hear you, Johnny, and I understand that you are out there kicking butts where you can, and I encourage it and I applaud you, but that is unfortunately the brick wall you're going to run up against in many cases. But the mechanism you're thinking of, FOIA, is probably the proper mechanism. All right. Let's keep it going here.
Hello, everybody. Happy Sunday Fun Day and happy Father's Day. Hi, Courtroom Confidential crew. This is Sonia from Chicago. So I'm not saying I'm punishing you, Josh, because we missed last week. I think we have to talk about the defense witnesses in the Karen Reed case. How amazing they were, how honest, and when you have the truth on your side and you get up there and you tell the truth, how much it shows. And can we just give a special shout out to Dr. Dimples? Yeah, because he's my favorite witness. And Josh, I guess the question is, who is your favorite witness out of everybody in the Karen Reed case now that it's got to be over? And maybe we even have a verdict by now. Thanks, everybody. Bye, guys.
Sonia, love you so much. Chicago, let's put Chicago on the map. Great question. We don't have a verdict yet. I'm not shocked by that. Anybody who thought a verdict was going to come back Friday after arguments and instruction, I mean, just wasn't going to happen in my view. But maybe tomorrow, maybe by Tuesday. I think if we don't get something by Tuesday, I think then people are going to start wringing their hands. But don't have a verdict yet. And so Sonia wants to put me on the hot seat and say, what are my favorite witnesses in this case? Her favorite witness was Dr. Daniel Wolf, I think for reasons including and aside from his courtroom demeanor. It could be that fresh face of his. I know he had a lot of fans. I thought he was a great witness too. I thought he did a very good job. He's obviously very smart, kept himself collected. Okay, so I thought a lot about this. For the prosecution, I think my favorite, and I don't want to say favorite, let's say most effective, okay? For the prosecution, who I thought was probably most effective, and I can already tell the grief I'm going to get for this, but I thought was Carrie Roberts. Carrie Roberts was important to the prosecution for many reasons. First of all, she receives the phone call from Karen saying John is dead before his body has ever been discovered. Not a small point. Somebody, an argument can be made that only people who are going to jump to conclusions that somebody is dead if they know that somehow they may have been harmed. And then we know later on that Karen was saying things like John was hit by a plow. Again, questions start to rise. Why is this person saying this if the person doesn't somehow know more information than what they did? Wouldn't the more reasonable response be, I can't find John. John didn't come home. Is John with you? Did John stay at the house? But this idea of John is dead, hit by a plow. Okay. Yes. And also, I don't think she carried as much of the kind of baggage as Jen McCabe. Jen was, there was a lot of contention. There was the whole Google search, all of that stuff. I thought Carrie Roberts was a good witness for the Commonwealth. And I can already hear everybody saying, but she lied and the perjury and the this and the that with the grand jury. I don't mean to be that guy who's always kind of like yawning in the back of the classroom, but it was like, to me, her explanation for what she told the Commonwealth and the difference from what she was saying now, I didn't chalk up to a lying liar who lies. I chalked it up to some damn good cross-examination by Alan Jackson and trying to make that moment as big and important as it was. But to me, it was not, it didn't blow me over with, oh my God, we've got a liar on the stand and this woman's going to get arrested. So that's for the Commonwealth. For the defense, I think the witness who I felt performed the best was Dr. Marie Russell. And what's funny about her is I don't know if this dog bite thing will carry the day or not. In fact, I probably think that it won't. I probably think that the jurors, the defense realized they needed an explanation for those injuries. They just can't walk away from this saying he was never hit by a car without providing the jurors with some idea of what could have happened. So I think the entire point of Dr. Russell was the what could have. Not what did, but what could have. If it wasn't a car, then what was it, defense? Well, it could have been a dog. And what I liked about her is first of all, she's got all the experience in the world. She's highly, highly experienced. You know, there's her experience is basically unimpeachable. She's not a professional witness. She is now, I realize, but at the time that she first contacted the defense, she was not a professional witness. She was just kind of a person who had been watching and thought she could add some insights. I thought it was very powerful and interesting that she approached the defense rather than the other way around. She was like just someone who wanted to get involved and help. And I felt that she was very good under cross-examination. So that's for the defense. But for myself, and this is not me trying to be cute by half, I have to say that the courage of Peggy O'Keefe, for everything that this woman has gone through, for everything that the loss she's experienced, and the everything that's gone on, it's a very difficult thing to take the stand and testify, realizing that you may have been under cross-examination. And I think it was a good moment for both the prosecution and the defense in that she was not exploited, and that the Commonwealth did not try to make more of her testimony, and that the defense thanked her and didn't question her. I thought it was very admirable, and probably the nicest point between all of the attorneys on this. And, you know, that poor woman, regardless of where you come out on all of this, she lost a son, and he sounds like he was an incredible guy. And I'm very sad for what she's going through. Yes, this is what it's all about. What a great guy, and what a loss for that family and that community. And what courage that woman showed. So thank you for that question, Sonia. All right. We're coming down to the end here, guys. Stick around. Got a few minutes left.
Good morning, Courtroom Confidential. This is Pam calling from Michigan. I did submit a question a week ago, but please delete it because it's so outdated. It was about the delaying tactics of Lori Vallow Daybell. But what a crazy trial with her and all the stuff. I don't know what else to say. Very interesting. Perhaps we can talk about that a little bit and the consequences or potential consequences. Also, I noticed that her appeal for Idaho is out. Would like your information on what the possibilities are of her hopefully not getting a new trial, because I just, worry, obviously, I'm sure like everybody else, thinking that there might be a reason or a possibility of her getting a new trial. But anyway, just thought I'd call and see if you can play this question instead, since we're hopefully at the end of the Lori Daybell trial in Arizona. Fingers crossed. Have a great day. Can't wait to listen on Sunday. Talk soon.
Thank you so much, Pam from Michigan. Sorry, I know you said don't play the previous one, and I meant to not play it, but then I'm glad I did play it because we got to talk about Ferretta and all of that. So don't apologize, and I'm sorry you said no, but I'm the boss here. I decide what we play. Anyways, Pam, thank you. This is a great question too about Lori Vallow Daybell, and the possibilities of her getting a new trial in Idaho. If you're asking me to handicap bets here, I'd say she has very little chance. That all being said, her argument is not without merit. Her argument is about her mental incompetency to stand trial. And you remember, she was in and out of competency. So that is squarely an issue. And it's no surprise she's making that her issue of her appeal, that she was not competent enough to stand trial. In fact, she had been declared incompetent, and she could just say, I never should have been declared competent, and then therefore the whole trial, blah, 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 blah. Here's the problem, though, and the irony of all of this. She likely undid her own chances of winning this appeal by representing herself in Arizona twice. She proved her competency to the courts in Arizona by representing herself. Her competency was an issue in Arizona twice. Not only her competency, but her ability to represent herself. And I think that she may have undid her chances of proving competency as being an issue in Idaho. And I realize we're talking about different times in different states. But if I'm the judges in Idaho, I'm saying, wait a minute, the lady who just represented herself twice and had her competency squarely at issue in Arizona is now trying to say she was incompetent to stand trial here. Good luck with all of that. Thank you, Pam, again for your call. All right.
Hi, Josh. This is Sneemac. Girl dads are a special breed among dads. And as the last of 4 daughters, I think I'm an expert witness on this topic. So I know an excellent one when I see one, and I definitely see one in you. So happy Father's Day.
Oh, Sneemac calling from Alexandria, Virginia. We're going to put you on the Mac, but you're going to make me cry. I'm glad that message didn't go on much longer. Being a girl dad is not something I imagined 5 years ago, but I am squarely both feet in up to my eyeballs, a girl dad now with 3 little ones. And I love them to death. And they've got me wrapped firmly around each of their little fingers. And I appreciate you saying that, Sneemac. It is a special obligation and honor that I carry. And, you know, now I just have to save up for 3 colleges and 3 weddings. So no big deal. We'll be able to handle that one. Thank you again. And happy Father's Day.
Hey, it's Lucia K. Mayo, Humboldt, Tennessee here. First of all, very happy Father's Day, Joshua, with your little Ritter critters over there, and to all the other fathers and father figures out there. Now, my husband knows that I am fascinated with the Titanic disaster, and he made me promise not to Google or research this, so I haven't. But he told me to ask you, Joshua, was there a serial killer or serial killers that roamed the Titanic? Thanks. Happy Sunday, fun day, and happy Father's Day to my fellow crewmates, moderators, guests, and of course, Joshua. Thanks, y'all. Bye.
Happy Father's Day, Alicia K. Mayo from Humboldt, Tennessee. I appreciate the well wishes. This cracks me up because I can just imagine this exchange between Alicia and her husband where she's wondering about serial killers on the Titanic and he's saying not again. No, you're not allowed to go Google it. But then he says, go ask Josh. Yes. And that's so funny. You call them the Ritter critters. That's what we call them too. Oh God, wait until they start dating. Don't say that to me. Do not say that. Now I've got nightmares. Alicia K. Mayo, I did the research for you. You can let your husband know. The answer is no, not that we know of. There was no serial killers on the Titanic, but there were 2 men who had committed murder. William Mintram was a fireman or stoker on the Titanic. He was convicted of manslaughter for stabbing his wife, but he had been acquitted of murder of stabbing his wife. So he stabbed his wife, got acquitted of murder, convicted of manslaughter, did whatever prison time, and then became a stoker on the Titanic. And then George Francis McGaw was an able-bodied seaman, so also a part of the crew. And he had previously killed another sailor on another ship during a fight, and he went to prison for a short period of time for that. So someone has done extensive research into this very question. I'm sure they know the background of everybody who was on that ship, but there were 2 previously convicted murderers on that ship as well, but no serial killers. And I hope that doesn't disappoint you, Alicia K. Mayo. Thank you so much for your question. All right. We're down to the final stretch here, guys.
Okay, Josh, this is Gina again, back with the second part of my question. What were the first true crime books that you read? I read Helter Skelter and In Cold Blood. Helter Skelter just disgusted and made me sick. In Cold Blood scared the right out of me. But anyway, to get to my questions and suggestions, what was the first major crime case that caught your interest and that you followed all the way through? And what was the first true crime book that you read? Also, maybe this would be an interesting topic of discussion for a members only or another Sunday Fun Day. Thanks. Bye.
Thank you so much, Gina. You had sent a previous message, and we weren't able to hear the audio of it so clearly, but I'm glad I got your question here. Calling from Chapala, Mexico. Appreciate the calls from our neighbors down south. Love this question. What is the first true crime book that I read, and what was the first major case that I followed? The first major case that I followed, I think, has got to be OJ. Living here in Los Angeles, growing up in Los Angeles, obviously the Menendez brothers was a big deal, and I knew about it, but I don't think I followed it like I did OJ. I didn't watch OJ every single day, obviously. I was in school, but it was just such a big part of the air here that you had to kind of know what was going on. And even I wouldn't even say I was like a true crime fan. I mean, I'm still in high school at the time. I'm not even, thinking about becoming a lawyer, but it was just something that we all knew. I mean, it was just, we all kind of knew what was happening. It was on the news. People were talking about it. It just affected life here. But the first true crime book I ever read, first of all, Helter Skelter and In Cold Blood, both two of my favorites and highly recommended. Helter Skelter, about the Manson murders, written by the prosecutor Vincent Bugliosi. It is an incredible book and something I read when I was first a prosecutor and affected the way that I looked at and treated that job. Highly recommended. And In Cold Blood by Truman Capote, also probably one of the, I think it's pointed at as the first to create this new drama, this new genre of the kind of narrated true crime story, a true crime story told in a novel, as if it were a fiction novel, told in that sort of narrative format rather than just a journalistic reporting of the events. Both great books. About In Cold Blood, about a murder of a family in Kansas. But the one that I think was the first one that I think of is Mindhunter by John Douglas. He was, they've created a series on Netflix about this now, but he was considered to be one of the first to start the behavioral sciences unit with the FBI, which is the what we now think of as profilers, before they even knew that term or what it was. And it's a fascinating book. Not what I would call, like, it doesn't follow one case. It follows many different cases and his career through the academy and everything else, and the development of the behavioral sciences unit. But really, really, first of all, graphic, got a lot of, disturbing stuff in it, but just also a fascinating book about how especially serial killers think and how they track them and are able to just, figure out how they think. So great book. If you guys haven't read it, please check it out. Mindhunter. Again, I don't get anything from that, and I don't know John Douglas, though I'd love to meet him, but it's a really, really good book. And on that note, Gina, thank you so much for bringing us home. That is our last call for today. This was fun. What did we talk about today? We talked about we talked about quite a bit about Karen Reed. We talked about Lori Daybell a bit. We talked about Luigi Mangione and the killers on the Titanic. Melody Farris, that video, you guys got to watch that whole thing. A lot of good fun stuff. A lot of calls from all over the world. Thank you guys so much. Happy Father's Day for being here. Here's some quick announcements for you. First of all, yesterday was our weekly roundup. We work very hard on the weekly roundup. Probably put more work into this than most of the other stuff. That we work very hard on everything, but we really try to make this a very polished product for you guys every week. If you haven't checked it out, please check it out. We talk about Karen Reed and Diddy and Donna Adelson and Lori Daybell and all of the cases that took place this week and what you should be following. Then all this week, obviously the trial's over, but we are in verdict watch for Karen Reed on the Courtroom Confidential live trials channel. So this is the plan. As soon as we hear that there is a verdict, we're going to be monitoring the monitoring. We will go live. And so if you want to watch the verdict with us on CC Live Trials, please tune in there. We will make sure to go. We don't think we're going to do every jury question. But we do want to make sure that we have the verdict. And if we can distinguish that, we will. But we want to make sure you guys don't miss anything. So that's all this week until they get a verdict. Monday, we're going to go live again, 5 p.m. Pacific, 8 p.m. Eastern. We don't have a topic just yet. So if you guys have something you want us to get into, a topic you want us to discuss, I'm going to be figuring that out today and tomorrow. And we'll come up with something good. But if you have some ideas, throw them my way. But please join us tomorrow because we're taking a little break from our conversation series while we're working on the next season of that. But we didn't want you guys to miss out on Monday night content. So 5 p.m. Pacific, 8 p.m. Eastern, join me live on Courtroom Confidential. Thank you so much, Rosie, for saying happy, fantastic Father's Day. And I will enjoy it. Thank you. And then finally, Wednesday, we're doing our Wednesday night live as we always do. Same time, 5 p.m. Pacific, 8 p.m. Eastern. And our guest this week is Kevin Fixler from the Idaho Statesman. We will be talking Brian Koberger, so come get your Fixler fix. I forget who coined that phrase, but Kevin Fixler this Wednesday, 5 p.m. Pacific, 8 p.m. Eastern. Brian Koberger will be in court on that Wednesday, so there will be stuff for us to talk about and some updates, and Kevin is the best person to do that. So join us this coming Wednesday. As always, guys, appreciate you all. If you want to know where to, I'm going to share my thing here. If you want to know where to join our membership program, then you have to go to thecourtroomconfidential.com, click on Become a Member, and you can learn all about the benefits of that. And we try to make it full of benefits. If you want to check out our merchandise, you go on the shop. You can check out all the shirts, including the one I'm wearing now, which is called... What is it called, Tiff or Kaylin? I'm going to guess Summer Popsicle Dream, something like that. It's a bluish green shirt, and I love it. I love all these shirts. They're the most comfortable and nicest quality stuff. We're very, very happy with them. That's for all the merchandise. It's the sea foam or chalky mint, robin's egg blue. Yes, perfect. That's it, says Tiffany. So I was right. It's Popsicle Dream. I don't know what it's called, but it's on the website. Sea foam. Okay, sea foam. But it's on the website. So go to the website for the shop. Go to the website for the membership. But as always, if you want to leave us a message, click on this button off here to the right. Send us a voice message, and we will be answering those all next week. So we'd love to hear from you, want to hear from you again, and want to hear from everybody who's been working up the courage to ask us a question. In the meantime, I hope that you guys have a very wonderful... Oh, I want to thank our mods, first of all, Kathy and Afton and Sonia. Thank you guys for all the work that you do. And thank you to Kaylin and Tiffany for all the behind-the-scenes stuff. Happy Father's Day, everybody, to the fathers out there, to the daughters of fathers, to the wives of fathers, to the fathers of fur babies and everything else. I appreciate you all. Have a wonderful Sunday, and we will be talking to you all soon. Take care, everybody.